Good morning, everybody. It is my honor and pleasure to welcome every one of you into our international conference, Adapting Global Justice to Russia's Crime in Ukraine. And as we know, the war in Ukraine, the big war, not speaking about the war that's ongoing from 2014, is already coming to its third anniversary, and the evidences of crimes, war crimes, crimes against humanity, maybe even genocide, is mounting, and justice is still not served. And as it is said in the very famous proverb, justice delayed is a justice denied. And that's why we are meeting again to discuss important issues on international responsibility of the crimes which are the heinous, most terrible, most perhaps important crimes in the history of the world that unfortunately are being committed every day on the fields and in the cities and in the towns of Ukraine towards and indeed, there is a big problem with this issue of justice to be delivered to Ukrainian people. And today we have a plethora of speakers to address many different issues regarding international crimes, international responsibility, both from a historical point of view up to the recent researches and jurisprudence. So I'm very glad to welcome all of you and also viewers on the YouTube channel. And I'd like to present a few rules that we will follow during this conference. First of all, every speaker will be accounted for 20 minutes for its presentation. And I also would like to ask to follow time clearly, because afterwards we have sessions for the questions. Also, I would like everyone to turn off the sound while the speaker is speaking. And well, I think if we will keep to those two rules, everything will be very fine and smooth and everything will be okay. And well, unfortunately, I forget to introduce myself. My name is Justyna Zilinskas. I'm from Mykolas Romeris University, and I will moderate this event, as well as I will take questions from the YouTube channel. So those who are watching us on YouTube, please do not forget to provide us with questions, and the presenters will answer them. And without any ado, I would like to welcome and to ask for the first presentation by Professor Yvonne McDermott-Rees from Swansea University from the United Kingdom. And the title of her presentation is Proving International Crimes. So Yvonne, the floor is yours, and we are keen to hear your thoughts.
Thank you very much. Well, let me start by saying thank you very much for the invitation, and thank you to the organisers of this fantastic event. I know it's been a lot of work to put it together, so I'm really delighted to be with you this morning. So I've asked been asked to speak on this topic of proving international crimes, and basically what can we learn from the practice of the International Criminal Court when it comes to proving the existence of atrocity crimes in Ukraine, and probably also in other situations as well. So this book has just been published. It came out last month on this same topic, published by Oxford University Press. And in this book, I set out basically the law of evidence in international criminal law. So I go through what principles should drive the development of international criminal evidence as a coherent body of law. And I also speak about things like different forms of evidence, what standards, if any, the international criminal tribunals have set out for different types of evidence, as well as how the evidence as a whole is evaluated, the structure of judgments, issues around appeal on findings of fact, and so forth. But today I'm going to focus really on the high-level findings of this book, and I'm also going to talk a little bit about the material in chapter 3, which is about the admission of evidence. So something I get asked a lot is, how do we preserve evidence to make sure that it's admissible before the International Criminal Court? Or what are international standards for the admissibility of evidence? And it's such a disappointing lawyer's answer that I always have to answer, well, it depends. It's not like the International Criminal Court has set out a checklist. If you want to see a video admitted, then you must do this, 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 and that. So that's a bit kind of tricky, I think, for people who are thinking about collecting evidence, preserving evidence now with the aim of future prosecutions in mind. But in another way, there's a real flexibility built in to international criminal evidence, as we will see. And what that basically means is that any evidence is admissible so long as it's relevant, it has probative value, so that means that it's reliable, it's significant, and that its admission isn't going to prejudice the right to a fair trial. And we'll talk a little bit about each of those, if you like, in the conversation afterwards. So without further ado, let me delve into that. So in thinking about international criminal evidence, in my book, I talk about, can we talk about international criminal evidence as a body of law? Again, often I'm asked, what does international criminal evidence require? But unlike domestic law, where we have these very well-developed structures of what a criminal trial looks like, and then our law of evidence kind of derives from that, whether it's an adversarial system where it's really the role of the judge is kind of like an umpire, compared to other systems where the judge is more active in fact-finding and maybe even in conducting investigations as an investigating judge. International criminal evidence has developed as the system of international criminal procedure has developed. And basically, it's kind of a pick and mix of different rules outside of those procedural paradigms, outside of those systems. So it's a blending of different elements of domestic systems with some unique facets. So there's a Philip Larkin poem about, I won't use the proper word because it's a little rude, but basically they mess you up, your mum and dad. They don't mean to, but they do. They give you all the faults they have and a few extra just for you. And it's a little bit like that with international criminal procedure. We take all the faults from domestic criminal systems, and then we add a few extras that are purely creations of international criminal law. So a good example of this is the doctrine of judicial notice and how that's developed as a very unique structure of international criminal procedure itself. And then, as I mentioned, there's a huge amount of flexibility built into the system. So each chamber in the International Criminal Court sets its own decision for the conduct of proceedings. And what this means in practice, and this has changed a little bit in recent years with things like the Chamber's Practice Manual, where chambers have tried to be a little bit more consistent. But in the early years of the court, we had a system where you might have two trials at the same time in the same building running what looks like two completely different legal systems. So judges can set in that decision on the conduct of proceedings decisions about things like the admission of evidence, how that's going to work, victim participation, what will that look like? And so very different procedural paradigms applied in two different trials at the same time in the same court in the same building. And that's as a result of the flexibility built into the system. So in my book, I talk about what principles should underpin international criminal evidence, and I argue that there are two. The highest standard of fairness, which is something I've written about elsewhere, and also rectitude of decision. So making sure that we reach the right decision. But all of this falls within the context of what some people have called the International Criminal Court's evidence problem. And we can refer here to several high-profile controversies, which are all really issues of evidence at the ICC. So in its very first trial, Lubanga, the trial almost came to an end because there was a controversy about the use of intermediaries, and the prosecution wanted to keep the identity of these intermediaries who had basically connected them with witnesses in the field secret. And then the defense said that this was an abusive process. And essentially a solution was reached, but only at a very late stage in the trial, where it really did look at one point like the whole trial was going to have to be indefinitely stayed for an abusive process. There was some controversy in the Katanga case where Katanga was charged under one mode of liability, and then towards the end of the trial, actually after Katanga had testified in his own defence, the judges decided to recharacterize the mode of liability under Regulation 55. And lots of people said that was unfair because he'd effectively admitted to his own guilt. Several cases haven't passed the confirmation of charges stage. So this is a very early stage where you just have to show that there are substantial grounds to believe that a crime has been committed within the jurisdiction of the court, and cases have fallen apart and have not proceeded beyond that very low standard of proof. Most recently, in the Central African Republic case, the case of Mokum, the prosecution said that key witnesses became unavailable at a late stage. We're still waiting to see what will happen with that. He's asked for some compensation and for further clarity as to why he was transferred to the court at all, and obviously deprived of his liberty. Bemba was acquitted on appeal, as many of you know, and another high-profile accused, Laurent Gbagbo, former president of Côte d'Ivoire, was acquitted at an earlier stage, so at what they call the no case to answer stage. So this is after the prosecution have presented their evidence. The defense can raise a motion saying, we don't need to answer to this because the prosecution's evidence is so weak that even if the defense doesn't bring a single witness, there's not enough here to sustain a conviction. And the trial chamber in Gbagbo and Blegude agreed and acquitted the defendant. So we have all of these issues that really are issues of evidence, not enough evidence to sustain a conviction or to even proceed beyond earlier stages of proceedings. And it's really led people to wonder, is there an issue here with how international criminal law as a structure works? Is there something going on here? And I think probably there's a range of well-established challenges in fact-finding that explain at least partly some of these big controversies in international criminal law. The time between the commission of the crimes and the trials themselves, the distance. So, trying to get witnesses to come to The Hague to testify. The ICC doesn't have the power to compel witnesses, unlike the earlier tribunals where they could effectively force people to come and give testimony. Of course, once a witness turns up in The Hague, they're compelled to tell the truth, but it's that thing of getting them to be willing to come forward and testify. State cooperation is a massive issue. And I think this, I don't know if anyone has been to the International Criminal Court recently, but it's pretty quiet there at the moment. There's one case, Saeed, going on. That's a fairly advanced stage of the trial. Others, Yekutiom and Gaisona has finished. So yeah, waiting for a judgment in that. Abd al-Rahman is more or less done. So we're really looking, and then there are no cases at the pretrial stage. Al Hassan, we've had a judgment, so that's at appeal. But we're really looking at a situation where possibly next year there will be 3 empty courtrooms in the International Criminal Court, unless states decide to transfer individuals to stand trial. And as you all know, including in Ukraine, there have been lots of high-profile decisions to issue arrest warrants. But unless you have states who are willing to transfer those individuals to stand trial, then there can't be a trial. I'm currently working on the case of Joseph Kony, who's the former leader, or well, the alleged leader of the Lord's Redemption Army in Uganda, and the prosecutor has asked to confirm the charges against him in absentia. So probably this is, or possibly this is seen as a way to address this shortcoming in actual activity in the court, that we proceed in absentia against individuals. My colleagues and I have challenged that this is all public, you can find it on the website, but we've challenged that this can even go ahead at all. So we'll wait and see what happens with that. But I mean, if that does go ahead, and if that is the way the court is going to proceed in the coming years, that's going to be a fundamental shift in what the International Criminal Court is and what it does. It goes from an institution that tries individuals to one that does, essentially in absentia fact-finding exercises without the presence of the accused, and that looks very different. Witness interference has been an issue in several cases. The big issue is often it's very well established that crimes happened, but in order to prove linkage, prove the responsibility of the individual on trial, that's where it gets really tricky. And that's usually where you need to have insider witnesses or documentary evidence, something to establish that this individual either ordered these crimes to take place, or that they were somehow in control of it, if it's an indirect co-perpetration case. So and again, this is something we think about a lot when we think about preserving evidence of international crimes. Often the existence of the international crime isn't the thing that's most difficult to prove, it's rather who's responsible for it. And when we think about documenting international crimes, that might mean documenting not just the atrocities that have happened, but also key contextual elements, maybe registration numbers of vehicles that are linked to the perpetrators, uniforms, signia, things like this, that later, once, maybe years later, if this comes up in court, that the parties can argue about who actually is responsible for the commission of these crimes. And the last problem, I would say, is the broad range of situations before the International Criminal Court. So if you've got lots and lots, and we see this at the moment where there are so many preliminary investigations going on in all corners of the world, but then an absence of, actual cases. So it's quite difficult to go deep if you've only got a couple of emblematic cases for each situation. So those are some of the challenges, but let me talk to you a little bit about the sort of flexibility built into the International Criminal Court statute. So I mentioned this already, that each trial chamber allows the court to, for example, rule on the admissibility of evidence. Article 69 talks about that the parties may submit evidence relevant to the case, and the court shall have the authority to request that, and the court may rule on the relevance or admissibility of any evidence. And then this is the thing I mentioned at the start, that the presiding judge makes a direction on the conduct of proceedings. And what that has meant in practice in some of the cases to date is that we have very different procedures depending on the chamber of the court that's hearing the case. That's probably not something the drafters ever intended, but that's just a consequence, I think, of different judges have different preferences, sometimes based on their own legal systems. And it's led to a sort of lack of coherence, perhaps in international criminal procedure as a model, but in issues relating to evidence in particular. And the biggest example of this is that in recent years, the court has moved towards what we might call a submissibility model or submission model for the admission of evidence. So this is where the court decides, or the chamber decides, that rather than deciding on the admissibility of a piece of evidence when it's presented before the court, they will defer the decision as to whether it's relevant and admissible until the end of proceedings, when it has a view of all of the evidence as a whole. So that's really a big difference to what we knew before, which was almost an adversarial type of thing. And while the chambers were very flexible in terms of what they actually admitted, you know, I would say roughly 90% of the evidence was deemed admissible, maybe even more. They were making those decisions as the trial went along. And that was quite useful for people like us who were thinking about, well, what are international standards? Because then we had particular decisions that said, oh, let's say the defense want us to admit this video. Well, does it have the metadata? Does it have the, do we know the source? Do we have a chain of custody? You know, all of these issues that would have been considered in those admissibility decisions. Because all of that is now deferred to the end of the trial, all we have is the trial chamber judgment. And usually it doesn't really go into a whole lot of depth about the particular considerations that were taken into account when deciding whether the evidence was admissible or relevant. So some of the arguments that are raised in favor of this model is that, well, the chamber is better able to assess at the end of the trial whether a piece of evidence is relevant. I don't find that particularly convincing, because if the parties can't explain at the time that they're seeking to see a piece of evidence admitted why it's relevant, then, you know, it assumes some sort of omniscience on the part of the chamber that they're able to decide or to see irrelevance that the parties themselves had missed. The second big argument is, well, look, you know, we don't have juries here in international criminal law. We're professional judges, and so we're well able to decide what's relevant, what isn't. At the end of the trial, we can take this holistic view of the evidence. But of course, judges in the ICC come from very different backgrounds. Some have a background in international law, some in criminal law. Even those who are in criminal law, they might not have been a judge. So this might be the first time they're ever sitting as a judge. And I think trying to filter down the record of evidence and make sure that it's only really the strongest evidence that's going forward to be considered, rather than flooding the evidentiary record with a lot of material of, you know, that's fairly weak as evidence goes, would be beneficial. There's also arguments around, well, it's more efficient, it leads to fairness and certainty on the part of the parties. But in my book, I talk a lot about how in Gbagbo and Blé Goudet, the chamber decided to follow this submission model. And then I think the prosecution was kind of blindsided, because they were submitting all of this evidence and they weren't getting any feedback. And then when the no case to answer judgment comes out, you know, Judge Tarfusser, the presiding judge who was from Italy, says, for 3 years now, I've been sitting watching this irrelevant, weak evidence been piling up. And I think that really highlights the danger of the submission model, that the parties actually don't have certainty as to what the chamber thinks of their evidence. And then that has a knock-on impact in terms of the final trial brief, your closing arguments. What do you rely on, or what do you need to go into detail about why a particular type of evidence is reliable or not? Or is the chamber already convinced of it? So look, it's... I'm conscious I've got less than a minute left, but it's something that perhaps it doesn't lead to the greatest amount of efficiency in the long run. And we could talk some more about that at the end. Just to wrap it up then, I would say inconsistency still abounds when it comes to international criminal law and the law of proving international crimes. What does the future hold for international criminal prosecutions? I think really it's going to be domestic jurisdictions that are really leading the way in terms of proving international crimes and prosecuting these international crimes. Certainly we're seeing a lot more activity in domestic courts today than we are in the International Criminal Court. And maybe that's a measure of success. Maybe this is complementarity in action. So thank you very much, and I look forward to any questions.
Yeah, Yvonne, thank you very much for your presentations. Indeed, you delve deep into ICC procedures. So, as you mentioned, we will take the questions a little bit later. And as well, I'd like to ask everyone who is watching us on YouTube, please think of the question, put forward your questions. We will be very, very glad to discuss all these issues. And now I would like to call up our second presenter. That would be Professor Dr. Thomas Weigand from University of Köln, Institute for Foreign and International Criminal Law. So we are very glad to have Professor Weigand here. So Thomas, can you please share your slides and we can continue.
Yeah, well, hello. First of all, I'm very sorry that I probably confused and concerned the organizers because I came in so late. But the reason is that I wasn't aware that our time zones differ. So anyway, I'm very sorry, but now I'm here and I'm glad to speak to all of you, and thank you for your patience. Let me see. This is my. Can you see my? Here it is. Can you see my slides?
Yes, we see.
Okay, then maybe I should. I don't know where to start them.
It's down the screen near the meter of the size. You can push the button and it will.
I don't know where
full
to
screen.
start this really. Anyway, maybe we can you see my slides?
Yes, we can. Only now it's not full screen. The only problem.
Yeah, I know, but I really don't know where to do this now.
If
maybe
you will,
maybe I can leave it like this, and you can still. No, no, okay.
Yeah. Can you please move mouse where the meter of the size is, and the first icon to to your left will be the full screen. Where? Yes, correct. And yeah, and two more. No, two more. Yes.
Like this?
No.
This? No.
That one.
This probably.
Yes.
No, yeah, sorry.
Perfect.
Okay. So my topic, of course, is very different from Ivan's, but I think it may also be of some relevance. I'm speaking about the aftermath of the National Socialist atrocities, and especially Germany's attempt to deal with the killings in the concentration camps, and especially in the camp of Auschwitz. Now I'm going back a bit to the time of 1945-46, when the Nuremberg trial of the main war criminals was over, and that actually met with a very mixed echo in the German public. Let me see, how do I move this? Yes, this is an overview of what you're going to see. Many Germans, not excluding those in influential government positions, thought that it would be best to concentrate on rebuilding the country and not to dig too deep into the individual guilt of people involved in the National Socialist regime at different levels. And many people claimed that they and most others had been unaware during the war of what happened to the Jews, and that only a small group was actually involved in the attempt at exterminating them. And in West Germany, prosecutors and courts started operating again in 1949. But in the early 1950s, they did not systematically investigate National Socialist crimes, especially not the crimes committed in the concentration camps. There were only a few individual trials of defendants, some of whom survivors had recognized by chance in the streets. And it was only in 1958 that the Central Agency for the Investigation of NS Crimes of Violence was installed in the town of Ludwigsburg in southern Germany. That agency, by the way, still exists and still collects materials that can be transferred to prosecutors' offices all over Germany. Now, one important background factor in starting the investigation of NS crimes in the late 1950s was the political situation in the two German states at the time. The leadership of the Socialist German Democratic Republic repeatedly accused the West German government of employing former National Socialist functionaries and of turning a blind eye to the legacy of the former regime. These allegations were not unfounded. For example, the Federal Chancellor Konrad Adenauer's personal Secretary of State, Hans Globke, had formerly been instrumental in drafting the legislation discriminating against Jews, which had paved the way for the Holocaust. The founding of the Central Agency for the Investigation of NS Crimes was one attempt to respond to the GDR's allegations of intentional inactivity in dealing with a National Socialist past. Now, given these timid efforts, it took the personal initiative and tenacity of one person, whom you see here on this picture, Fritz Bauer, for making possible in 1963 the trial of 20 persons involved in the Auschwitz concentration camp. Fritz Bauer, who was Jewish, had to emigrate from Germany in 1936 as a young lawyer and survived the war in Scandinavia. After his return, he became Attorney General of the West German state of Hesse. Based on a pile of valuable documents that had been saved from the ruins of Auschwitz by a witness and passed on to Bauer, he obtained jurisdiction to prosecute defendants from various German states in one joint trial, which was eventually held in Frankfurt. The trial had been preceded by a judicial pretrial investigation, as was prescribed by law at the time, which began in 1961. The investigating judge interviewed 130 witnesses and collected a host of documents. Some of the original 24 suspects died during the investigation or became too ill to be put on trial. In the end, 20 defendants appeared at the Frankfurt District Court, which sat with 3 professional judges and 6 lay judges. The defendants had held a wide range of posts in the Auschwitz concentration camp. They reached from Robert Murka, the deputy commander of the camp, to Emil Bednarek, who was a prisoner at the camp and had been appointed to oversee his fellow prisoners in one of the barracks. Some of the defendants were medical doctors who were involved in the selection of incoming prisoners for the gas chambers. Others were employed as guards or involved in administrative functions at the camp. The trial lasted for 1.5 years. The court heard 360 witnesses, and the depositions of several others were read into the record. Most witnesses were former detainees, some of whom had traveled to Frankfurt from Eastern Europe. The defendants, all of whom were assisted by lawyers, did not admit guilt. Some even denied that they had been aware of the mass killings. Others claimed that they would in any event not have been able to prevent the killings, or that they were under duress or had to obey military orders. The defense also maintained that many witnesses from Eastern Europe had been manipulated or bribed by communist handlers in their home countries. Now, let's move to the results. The court acquitted 3 of the 20 defendants. Of the remaining 17 men, 7 were found guilty of murder, and 10 were convicted of aiding and abetting murder. The Federal Court of Justice later upheld the judgment except for the conviction of one defendant who was eventually acquitted after a new trial. Now, to the legal issues. There were, of course, problems of proof, as is evident like 20 years after the events, but there were two main legal issues to be resolved in adjudicating the defendants. First question, who could be regarded as a perpetrator of the killings committed in the concentration camps? And second, were the killings at Auschwitz one consolidated enterprise of mass murder to which each defendant had contributed, or was each instance of killing to be treated separately? Now, the first question, the Frankfurt District Court stated that the perpetrators of the mass killings were the highest-ranking figures of the NS regime, namely Adolf Hitler, Heinrich Himmler, Hermann Göring, and Richard Heydrich, the chief officer of the Reich Main Security Agency. These persons, the court said, had planned the extermination of European Jews and had organized the apparatus to carry out their plan through a multitude of subordinates who were subject to their orders. According to the logic of the court, this meant that the subordinates, regardless of where they were situated in the large organization and what their function was, normally were only aiders and abettors to murder. Exceptions were recognized only in cases where a subordinate committed arbitrary individual killings beyond and even against the orders he had been given, or where a defendant had personal motives for killing beyond his wish to carry out orders, for example, that he acted on his personal belief that Jews did not deserve to live. Such personal motives were, of course, almost impossible to prove, since none of the defendants confessed to having them. And even regarding ardent followers of the NS ideology, the court applied the rule in dubio pro reo and assumed that they were mainly motivated by the desire to carry out orders. The theoretical background of this analysis was the general view of German courts at the time that a distinction between perpetrators and mere aiders could be made only on subjective grounds. A perpetrator, according to that theory, was a person who wished to commit the criminal act as his own. An aider and abettor, by contrast, had the subjective attitude of wishing to support someone else's criminal act. Now to the second question. Fritz Bauer, the initiator of the trials, had meant to use that trial to show that the master plan to kill the European Jews was one big conspiracy which was to be viewed as a whole, with the consequence that everyone involved in that enterprise in any way was to be convicted for his role in it. This idea was not, however, accepted by the Frankfurt District Court, which treated the mass killings in Auschwitz in the same way as individual cases of homicide. In order to convict someone as an aider and abettor, it had to be proved that he contributed to a particular act of killing an individual or a group of individuals. Consequently, many of the defendants could be convicted of aiding murder only because it was proved that they had been present at the ramp where incoming inmates were selected for working or for being led directly into the gas chambers. Since this selection process resulted in the immediate killing of many of the arriving victims, those active on the ramp, even in supportive functions, were determined to be involved in the act of killing individual persons. But the court emphasized that it had to be proved that the defendant did not just carry out some function in the death camp, but that he actively contributed to individual acts of killing. Based on that reasoning, the district court acquitted Dr. Schatz, who worked as a dentist in the camp and treated SS members for toothaches. On appeal, the Federal Court of Justice approved of that line of reasoning. Now, in the interest of time, I jump a bit forward. Those defendants found guilty as perpetrators of murder because they had killed persons arbitrarily and without being ordered to do so, received life sentences as provided by law as the mandatory sentence for murder. The defendants convicted of aiding and abetting murder in multiple cases received prison sentences between 14 years and 3 years and 3 months, the latter sentence being close to the statutory minimum. The court explained that despite the high number of victims, the sentences should not approach the statutory maximum because the defendants were themselves indoctrinated victims of a terroristic and abusive system. Most of the convicted defendants served their sentences in full. Some were conditionally released after having served 2/3 or more in accordance with applicable German law. Now, there are some further developments which I will talk about briefly. The fact that both the District Court and the Federal Court of Justice held that even persons who had killed the victims with their own hands were to be regarded as mere aiders and abettors to murder was heavily criticized by scholars. This criticism probably was one reason for a new formulation in the German Penal Code, passed in 1969 and still enforced today, which reads, "Whoever commits a criminal offense himself or through another person shall be punished as a perpetrator." And commission through another person, according to the case law of the Federal Court of Justice, also covers the situation where the perpetrator is at the head of a political or military organization and where he can rely on his orders to be carried out through a system of strict obedience. Now, as we have seen, the Frankfurt District Court had insisted that every person involved in mass killings and other abuses of the NS regime must be adjudicated on the merits of his own active involvement in individual offenses. As a consequence, in the following years, there were no further trials of groups of defendants, but those suspected of having taken active part in the killings were tried individually. Given the passage of time since the 1940s, the number of suspects still alive and fit to stand trial gradually diminished. One late effort of adjudicating the responsibility of a concentration camp guard was the trial in 2010 of John Demjanjuk, held in Munich. Demjanjuk was an Ukrainian prisoner of war who, in 1943, volunteered to serve as a guard in the concentration camp of Sobibor. The Munich District Court convicted Demjanjuk of aiding and abetting the murder of more than 27,000 Jews killed in Sobibor during his term of service there, even though it could not be proved that the defendant had personally killed anyone. Demjanjuk appealed his conviction, but died at the age of 92 years before the Federal Court of Justice could decide on his appeal, and his conviction thus did not become final. A few years later, the prosecutor's office of Lüneburg filed an indictment against Oskar Gröning, then aged 93 years, who had served as a member of the SS in the Auschwitz concentration camp. The Lüneburg District Court convicted Gröning of aiding and abetting the murder of 300,000 Jews in 1944 and sentenced him to 4 years imprisonment. Gröning's appeal was dismissed by the Federal Court of Justice, and he eventually died in prison at the age of 96 years. Gröning's conviction did not present major problems to the extent that it could be proved that he was sometimes present at the selection site at the entrance of the camp, guarding the luggage that incoming detainees were ordered to deposit there. But Gröning's main function in Auschwitz did not involve his presence at the selection procedure. He was tasked with searching the detainees' luggage for money and valuables, and then to transport anything of value to Berlin, where it was transferred to the SS. Although this activity was not related to the killing of the detainees, the Federal Court of Justice affirmed his conviction of aiding and abetting the murder of all Jews from Hungary who were transported to Auschwitz and killed there in 1944. The Federal Court of Justice argued that the existence of an organized system of mass killing in Auschwitz was a prerequisite for the ordering of the so-called Hungary Action of 1944, which involved the transportation and killing of 500,000 Jews from Hungary. According to the court's judgment, the NS leaders gave the orders for the Hungary Action only because they could rely on the cooperation of many willing and obedient subordinates in Auschwitz. The defendant was held to be part of this killing machine, even though his main task consisted only in transferring the valuables of the killed persons to Berlin. This line of argument echoes what the Hessian chief prosecutor Fritz Bauer had claimed more than 50 years before. Everyone who willingly and knowingly played a part in a death camp's killing machine could be held responsible as an aider and abettor of all acts of murder that occurred during his time of service. It is interesting to see that the Federal Court of Justice in the Gröning judgment did not openly challenge the contrary finding in the same court's appeals decision in the Auschwitz case of 1968. Instead, the judges in their decision of 2016 claimed, implausibly, I have to say, that the court's earlier statements limiting criminal responsibility to those who had directly contributed to killings had referred to a different factual situation. Now, I will cut short the latest case, which was actually decided this August. It concerned a secretary, a female secretary who worked in the Stutthof concentration camp, Irmgard Furchner. And here again, the Federal Court of Justice found that anyone who was involved, even in a supportive function, in the organization and administration of a concentration camp where killings were done on a grand scale, was an aider and abettor, even if this secretary's action, of course, was far removed from the actual killings. But she typed the orders and the correspondence of the chief of the concentration camp, and therefore was also convicted. And maybe my concluding remark would be that the adjudication of war crimes and crimes against humanity in the context of Russia's present war of aggression is bound to present a host of problems that differ from those of German concentration camp cases, but the problem of determining the criminal responsibility of persons who are not at the top, but within the lower ranks of a large military or political organization, is likely to present itself in one way or the other when potential Russian perpetrators will be brought to justice. And perhaps the German experience in addressing the mass killings committed under the National Socialist regime can be of help in resolving this problem. Thank you very much.
Thank you very much, dear Thomas, for your presentation. And now I'd like to turn to the questions. And even though we don't have any questions on YouTube, but again, I would like to encourage those who are watching to put their questions there. But still, I would like to have some questions towards our first presenters, so Professor McDermott Rees and Professor Weigand. So, so please, everyone, you can raise your hand, those who are on the Zoom, and again, for YouTube watchers, you can post your question on YouTube chat. So we heard two very different, in fact, presentation, and one is one refers to today's problems of the International Criminal Court, basically to evidence issues. The other one is from yesterday, even though, let's say, the story continues up to now, as Professor Weigand mentioned with the latest case. And I'd like then to start the Q&A session and to try to initiate discussion. So first of all, I would like to address Yvonne. So Yvonne, you have said that that now the International Criminal Court perhaps will move to in absentia mode, having in mind that it's very hard to get hands on the perpetrators. So can you please elaborate a little bit more? And as far as understood, you do not consider it as a right path, basically, and well, even despite the legal issues that it will raise, perhaps it will have much more problems like we have with the issue of coherence and maybe even of the fragmentation of the law. So, and for the Professor Weigand, I would like to ask the question that sounded rather strange to me, because when you talked about those trials, the main actually qualification of the acts of the perpetrators were murders. And I wonder why maybe what was the reason why, for example, the issues of crimes against humanity or genocide was not put in place. Because as far as I remember from the Control Council law of the occupied Germany, there was legislation possible. So maybe you know why the way of the ordinary procedures on, let's say, murder were chosen and not the international crimes. So thank you very much.
And
So,
thank you oh, sorry.
mhm.
Thomas, do you want to go first? Or no,
No, you go first. You go.
Thank you, Thomas. So I'll answer your question first on in absentia trials, whether these would be a good idea. So let me provide a little bit more context. Article 61 of the Statute of the International Criminal Court says that the charges can be confirmed in the absence of the accused under certain circumstances where the accused has waived their right to be present, or where the person has fled or cannot be found. And in the Coney case, the prosecutor has asked to proceed with the confirmation of charges in absentia on the basis that Mr. Coney is a person who cannot be found. Looking at the ordinary meaning of the term cannot be found, as well as its object and purpose, as shown by the drafting history of the provision and its context within the statute, which includes, for example, a provision on the initial appearance of the accused, it becomes very clear that actually what the drafters had in mind was a situation where someone had made an appearance, had made an initial appearance, and then later had, for either deliberately evaded the justice of the court, so there's someone who has fled, or for reasons that are unknown cannot be found. So we've argued that in the absence of an initial appearance, then it's actually contrary to the statute to proceed with the confirmation of charges in absentia. Article 64 of the statute is very clear that trial has to be in the presence of the accused. But already some exceptions to this have been carved out. In the Kenya cases, some of the defendants who were by this time high-profile politicians in Kenya had asked for to waive their right to be present at trial. So look, this is not based on any inside information, but I can assume, or I guess that possibly the next stage, if a confirmation is permitted in absentia, a next step might be for the prosecution to say, you know what, how about we just go for a full trial in absentia? And of course, there'll be arguments where the defense will say, no, it's not allowed. You have the right to be present at trial. Article 64 is clear. But because this statutory provision has already been sort of manipulated and molded in a certain way through practice of the court, it's actually not completely unforeseeable that the court might decide, actually, yeah, perhaps we can do trials in absentia in certain circumstances. Would that be a good idea? This is the kind of thing where I'm conscious, look, I'm from a common law system. We're very much in favor of the trial in the presence of the accused, and that in other systems in absentia trials are commonplace, including in Ukraine. But I think for the International Criminal Court, there would be issues around the legitimacy of proceedings where we're proceeding with these trials without the accused being present and being able to challenge the evidence against them. But I think there's probably a bigger practical issue, which is the cost of international criminal trials and whether actually state parties would be happy to continue to fund an institution that's putting on these trials without the accused being present and effectively without any consequence, because it's not like, oh, once the only thing stopping international criminals from being locked up is the absence of a judgment. Those judgments effectively would be unenforceable until the accused is captured, and then they'd be entitled to a retrial. That's well established under international human rights law. So we saw it with the Special Tribunal for Lebanon, which did allow in absentia trials. you know, massively expensive. I think in the end it costs something like, when I say it, it seems so obscene. But yeah, hundreds of millions of dollars to try these 5 defendants who, you know, no one knows where they are still. Perhaps they're dead, who knows? And, you know, with very little consequence. So I think there are some broader practical considerations to consider if the court was to go down that route. Who knows? Maybe it won't. You know, maybe this Coney experiment will end wherever it ends, and that'll be the end of that. But yeah, I think it's something that needs very, very careful consideration if this is to be the future direction of proceedings.
Thank you very much, Yvonne. And can I address Thomas now?
Okay. Well, thank you. It's Justina, this is a very good question. It never came to my mind, actually, and I haven't seen anything on it. The reason may be that the crimes against humanity were not part of domestic law in Germany, certainly in the 1960s. It were only put into our code in early 2000s. Genocide, in fact, may even be in the 1960s. It may have already been in the penal code, but barely anyone knew about it, and so I don't. It probably didn't. Maybe it did come to the mind of Fritz Bauer, but I think if I try to guess what his considerations may have been, that proving genocidal intent to these low-ranking people might have added even more problems of proof to this trial. And since murder already carried a life sentence, probably he thought that it's not worth going into that specific crime, although, of course, in the interest of complete adjudication, it would have been a good idea to talk about genocide here.
Okay, thanks a lot. And now I have the second question for Yvonne from Dovile Sagatiene, so one of our participants. So, and the question is of very general character. So, why international criminal law is not working? And perhaps because of that, the cases are moving to national jurisdiction. So, also, Thomas' opinion also will be very worthwhil on this issue. So how do the presenters view let's say from those different perspectives, the current status of international criminal law and general efforts to work more from the point of view of universal jurisdictions and national proceedings to deal with the international crimes? So please.
So to start with the first part of the question, why is international criminal justice not working? Well, let's unpick that a little bit. Is international criminal justice working or not? So to start with the International Criminal Court, you know, we often have this criticism that the court's been in operation for over 20 years now, 22 years, and it's had a relatively small number of cases. Something like 10 defendants have been convicted by the end, 5 of whom were convicted for offences against the administration of justice, so interfering with witnesses. So of the core international crimes, it's 5 or perhaps 6 by now, final convictions. So that's, yeah, it's probably not the best track record in terms of, 20 years of activity. But by another view, international criminal justice is working, and the International Criminal Court is working exactly as the drafters intended for it to work, which is to continue to protect the interests of powerful states, and for this to be, sorry to get a bit too political or philosophical about it, but those cases that managed to make it to trial in the early days of the court, they were all African defendants. You know, and now when the prosecutor is saying, I'm going to issue an arrest warrant for Putin, I'm going to issue arrest warrants for Netanyahu, for these high-profile defendants from states with, you know, with greater sort of power on the global stage, then that's where we see, oh, this actually isn't going to happen. You know, there was this controversy recently where Putin visited Mongolia, a state party of the International Criminal Court, and the state refused to transfer him over to the court to stand trial, despite the fact that an arrest warrant has been issued and that's publicly known. So yeah, that's where we're at with the International Criminal Court. I think the big issue is that states are happy to support the court where it supports their interests. And that's not just state parties, that's also states like the United States, who have this quite, I guess, inconsistent view when it comes to the court. When it's going after, you know, the Africans, the US is saying, oh, we're going to give a big reward to anyone who can transfer this individual or to anyone who has any information. When it goes after its friends, then, you know, the US is saying, this is terrible, we're going to sanction people who work in the court. So yeah, I think perhaps the court is working exactly as the drafters, the states intended for it to work. And that is to say, at the moment, not very well. But look, you know, there is a positive light in all of this, which is this growth of domestic prosecutions for international crimes, not just in Europe. You know, we've had a lot of attention on the prosecutions in Germany, in France, in Sweden, the Netherlands, dedicated war crimes investigations offices as part of the domestic public prosecution services, but also actually in states so like Iraq, for example, where they're trying ISIL individuals who are responsible for crimes committed by ISIS, Daesh. In the Democratic Republic of the Congo, in Uganda, the International Crimes Division has just convicted Thomas Coelho. So we are seeing a move towards justice in a national level, and I think that's a really positive development. Here in the UK, we're lagging a little bit behind. We haven't had any prosecutions for international crimes for over a decade now. And I think that's something like 3 in history. This is probably due to our own very restrictive laws on who actually can be tried for universal jurisdiction offences. So in our domestic legislation, we have a residency requirement. The person has to be either a UK citizen or lawfully resident in the UK. And that sort of limits our ability to try, for example, individuals who are passing through the airport. But yeah, this is a positive development, I think. And this is probably where we're going in international criminal law, that we rely more and more on states to take the initiative to prosecute these individuals.
Thank you very much. Thomas, would you like to add anything to these thoughts and considerations?
Well, I could just sum up what Yvonne has so perfectly said. If on the positive side, one can say that if the international criminal justice works the way it is designed to work under the complementarity principle, then the perfect state is where the International Criminal Court has nothing to do. But of course, on the negative side, we see that if the international community, whatever it is as a whole, tolerates certain international crimes by powerful people, then there will neither be a prosecution nationally nor a prosecution before the ICC, because these persons will not be surrendered to the ICC. What we can hope for is, that goes back to the German experience, that times will change. And I remember the Milosevic situation in Serbia, where people said, well, he's so powerful, he will never be adjudicated. And then he lost his power, and that may happen to some other people as well in the future.
Okay, thanks a lot. Well, yes, in fact, it's very hard in a way to believe to the on the effectiveness of let's say of the international criminal justice. But anyway, I think it's better to have certain justice present as no international justice institutions at all. So now I would like to move to one more question presented again by our colleague Katerina Latish, who will speak a little bit later. So her question is that a lot of information to prove genocidal intent in the Ukraine cases of genocide is collected from open source now. So what would be recommendations on what is important to concentrate for prosecutors during the collection of such kind of evidence to be admissible in the court then? Of course, your recently proposed guide has plenty of recommendations for judges, but still maybe several key things for prosecutors from the judges' perspectives would be good. So I think this question is for Yvonne. So Yvonne, if you please, can you give some thoughts? Thanks a lot.
Thank you so much. So thank you, Katerina, for the question. Katerina's mentioned, I'll just share briefly. So I work on this project called the True Project, and we've recently published a guide for judges and fact finders for evaluating digital open source information. And it's also available in Ukrainian, thanks to our wonderful translation. So yeah, you can find that on our website. It's trueproject.co.uk/OS guide. Thank you, Katerina. So in terms of what do prosecutors need to focus on when they're collecting and preserving this kind of evidence? Again, related to some of the things I mentioned in my talk, we don't have a very clear set of like guidelines. This is ABC, this is what you need to do. But we do know that when we're thinking about the admission of this kind of evidence and ultimately whether to give it weight in court, the courts in whatever jurisdiction will be concerned with its reliability. So I would say there are two key things to bear in mind when collecting and preserving open source information. The first is completeness. So the completeness of the record, and that includes things like metadata. If it's a web page, making sure that that's archived in such a way that it can't be questioned, that its authenticity later in court. Often material on the internet gets taken down, and so it's important to preserve it in such a way that its authenticity can't be disputed later. So it's making sure that it's properly archived, all of the relevant information is saved about it, and that its chain of custody is very clear. So at this moment, when it was captured, we can show that it wasn't manipulated by anyone else or edited in any way. So there are programs out there that assist with this, including using things like blockchain technology to preserve evidence of this nature. The second thing I think is really important is objectivity and completeness in that sense. So making sure that when this evidence comes to be presented in court, a clear likely challenge by the opposing party might be, well, this is incomplete, it's a biased investigation, only certain things were cherry-picked, you didn't take the whole record. And look, that's not a criticism of lawyers who raise these arguments. Justice is a machine. We're all just cogs in the machine, and we're just doing our job. The person who wants this evidence to be admitted and relied upon wants to make the case that it's as reliable as possible. The other side wants to pick holes in the reliability of that evidence. So I would say being very objective, and that includes actually collecting evidence that maybe shows an absence of genocidal intent, or that maybe goes against the thing that you think this proves. So making sure that it's a complete record and that the impartiality of it can't be disputed in later cases. Those would be two key findings, but as you say, more in the guide if anyone wants to take a look. Thank you for the question.
Thank you very much, Yvonne. So, and I think due to our time limits, we have to move forward. So thanks a lot for Yvonne, for Thomas, And of course, we would like you to stay if you have such a chance. And now I would like to move forward to Dr. Monica Rogers, she is the head of the MRU, Memory and Justice Research Center at Mykolas Romeris University. And she will talk about issues related to Lithuania's dealing with genocide, crimes against humanity, and war crimes in Lithuania. So, Monica, the floor is yours whenever you're ready. Thank you.
Thank you, Justinas. Thank you, everybody. I'm very, very grateful that we managed to organize this event. Also, special thanks I would like to say to Dovilė Sagatienė, who was the main organizer of this seminar. I want to ask, do you see my slides? Okay, wonderful. So maybe just in the beginning a little bit about the project itself, the project that funded this event, this webinar. So we have a project funded by the Research Council of Lithuania, and the project title is Seeking Justice for the Victims of Genocide, Mass Repressions and War in Lithuania and Ukraine, Law, History and Memory. So I'm also very grateful for this funding, and we try to look into the evidences and developments that are related to historical dimension. So we are actually interested to compare the cases of Lithuania and Ukraine since very early, since the post-Soviet transformation, when these countries started seeking justice for the victims of the past crimes, such as Holodomor in the case of Ukraine, or for instance, Holocaust, Soviet deportations in both countries, and so on, and see if somehow historical memory and the interpretation of these crimes from the historical perspective had some kind of impact on the process of transitional justice in general. Of course, maybe it's even a naive question when I think about it now. We are our second year in the project, and myself as a historian, probably I was more familiar with this historical side of things, not the legal one, but now I see that those two dimensions are really, really close and sometimes inseparable. And specifically in the cases of crimes that took place a very long time in the past, like in the case of Lithuania, only in the 90s, the investigation started of the crimes that took place maybe in the 40s or 50s during the Soviet and Nazi occupation. And because of such a long period without investigation, without applying the tool of law, in, first of all, international law, then of course national law, somehow a lot of how to say, subjectivities formed, and a lot of interpretations comes now from the narratives that were formed within Lithuania that was living in the conditions of the Soviet occupation, of the Iron Curtain, and outside of Lithuania, that was in the case of Lithuania, probably Lithuanian diaspora, in the United States and Western Europe, trying to explain those crimes, but without really having archival sources, without having enough of evidences, without having access to many victims. And that was some kind of very, very subjective interpretation. But when the possibility to reconstruct the rule of law and to really investigate those crimes finally became possible, then those subjective interpretations started to influence public opinion very much. And that put a lot of pressure, I think, also to the legal system and to the transitional justice process in general. I don't know why, but I don't think I can change. Okay, yeah, I see here. So yeah, so the aims, as I said already, is about these different ways how to achieve justice. as I said, because I focus to transitional justice, I don't only talk about criminal investigations, but also the other ways how to achieve justice, other legal ways when criminal law is not possible, because, for instance, the crime took place so long in the past that there is not a live perpetrators, not live witnesses, and so on. In some of these cases, of course, trial can still happen, for instance, if the perpetrator is still alive, but it's just much more complicated. So in Lithuania, as I mentioned already, because of this historical dimension, there were some sort of specifics and subjectivities. Maybe other countries share also similar experiences. But however, since the regaining of Lithuanian independence in the 1990, it was this huge wish and this huge aspiration to somehow regain the justice for those victims. And first of all, it's because Lithuania, after Soviet times and Soviet law, tried to reform its legal system and come back to the rule of law, come back to some kind of justice in general. So this to come back to basically Western legal order or international legal order. So that was one of the motivations to rebuild also this to somehow start the investigation of previous crimes against humanity, war crimes, and so on that were committed during Soviet and Nazi occupations. Also, of course, the victims organizations finally gained their voice after many years of being shut down and silenced by the Soviet regime. They finally could speak out their experiences and claim for justice, and also because of that justice somehow, and that narrative about victimhood of Lithuanian nation became some sort of, during Soviet occupation, some sort of important narrative of national identity. So it was also somehow matter of national honor or something like that. And as I mentioned already, Lithuania also, of course, signed international treaties, documents, such as Genocide Convention. So there was a need to do something about it. But also from this dimension, this historical dimensions, came some subjectivity. For instance, this idea was very strong in the 90s that Soviet crimes were also genocide, and for instance, Soviet deportations. Now, probably lawyers don't think that all Stalinist deportation qualify for genocide. There are maybe some deportations that a number of deaths was very high that maybe could qualify, but again, this is just a discussion between historians and maybe some lawyers, but not really having any legal action. However, that narrative that also Soviet crimes were genocide, just like Nazi crimes and Holocaust, was very strong in the 1990s, and that was reflected in the first laws passed with this intent to prosecute former Soviet and Nazi war criminals and those perpetrators responsible for crimes against humanity and genocide. Of course, there was no question, of course, that Holocaust should be treated as genocide in Lithuania. That was pretty obvious, but that in Lithuania from the 90s, it was also somehow this idea that more crimes qualify for genocide. And now this is a little bit different. Some of Soviet crimes, as courts have proved, do qualify for genocide. Maybe Dovilė Sagatienė is more expert on that, but just to mention that. But also, those crimes against humanity, genocide, and war crimes in early 2000s, when Lithuania finally drafted its own, not a Soviet anymore, but its own separate criminal code, were included, and they are included, they are treated seriously. And also in Lithuania, where in criminal law, there is also criminalization of promoting and incitement of hatreds against the groups of people because of their nationality, publicly denying or grossly belittling of international crimes. So yeah, I'm referring basically to the 2008 framework decision on combating certain forms of racism and xenophobia in Lithuania. That was the European decision, but also Lithuania criminal law is actually applying that decision, and yeah, denying Holocaust, well, at least in theory, should be treated as crime in Lithuania. If I'm not right, maybe Dovilė can actually explain more on that, because she's more expert on this. Although there is maybe enough of laws and existing legal mechanism, there is not always easy, and there not has been easy, especially the 1990s, to actually have those perpetrators prosecuted. First of all, of course, because the crimes took place so long, so many of them were already dead. Many of them were in different countries, needed extradition. Many of them were prosecuted, like these Nazi perpetrators listed here in my slide, but the trials were delayed because of their old age and all sort of issues. Also, sometimes when Lithuania tried to prosecute Soviet perpetrators, it was another problem, because European Court of Human Rights reconsidered the local court's decisions as not valid, because the perpetrators claimed that this law cannot be applied retroactively, because local courts maybe not always knew how to apply the definition of genocide in correct manner, and maybe those were not genocide but crimes against humanity that local courts called genocide. So there were a lot of problems. Some sort of breakthrough happened in 2019 in the case Drėlingas versus Lithuania, when European Court of Human Rights actually agreed that the decision of Lithuanian court that this person, Drėlingas, was responsible of Holocaust against Lithuania, I'm sorry, not Holocaust, but genocide against Lithuanian nation, even though it was a Soviet times, the Soviet perpetrator was actually a valid argumentation, and Lithuania could prosecute this person for genocide. Again, Dovilė is more expert on that, but I know some things, of course, about it. And yeah, there were other attempts, like 1991 in Lithuania happened some kind of Soviet aggression and war crimes against civilians, crimes against humanity against civilians. Soviet military violated international humanitarian law and opened their weapons against innocent peaceful civilians in Lithuania and Vilnius, and that was also some sort of very difficult prosecution, but some success was achieved. But it was also for Lithuania this training how to apply trial in absentia against these perpetrators and so on. Then there are laws that, because so many of those perpetrators were already dead, so many of the evidences could not be collected because of already mentioned reasons. There was also a strong focus on how to compensate victims and how to honor those victims in Lithuania. So some laws were passed just to somehow give victims some kind of status, like for instance, the status of victim, the status of hero, which means those people who were resisting Soviet and Nazi occupations, and also some kind of, even it included, and it still includes some kind of material compensations. Also, what's important to look into the restitution of the nationalized or lost properties during those times. Not very smooth process, but something was done, and also then, of course, illustration and legal documents, legal documentation, publishing of that, and so on. I mean, the documents and archives of former, for instance, Soviet surveillance, KGB, and so on. Also, Lithuania has administrative laws banning certain symbols because there is belief that those symbols themselves, like, for instance, Nazi swastika, can incite hatred or somehow violate the justice for victims. So that list of those banned symbols was for using those symbols in public, you can get fine, administrative fine. So the list was expanded after the full-scale invasion to Ukraine. So now, for instance, the symbolics used by Putin's regime also is illegal in Lithuania. So is the national anthem of the Soviet Union, for instance. So these prosecutions really happen. As historians, sometimes I even get requests to identify if that's a national anthem, for instance, of the Soviet Union or not, and like these things happening, but not very smoothly again sometimes. And also there are some kind of non-criminal sanctions against perpetrators, like related to illustration, for just as example, former KGB officers or officers of certain Soviet institutions of power cannot take some positions of power in current Lithuania, or if the politician is running for the election, they need to declare their membership in the Communist Party. And this is more related to lustration process. So as I mentioned already, there were certain difficulties with this process in Lithuania. First of all, I was here talking mostly about post-Soviet transition and later transition after joining the European Union that strengthened the cases of these persecutions and trying to bring some justice for the victims. But these attempts to somehow prosecute, for instance, Nazi perpetrators happened already historically already during the Soviet period, and there were some trials during Soviet times of former Nazi perpetrators. But the problem is that without a rule of law existing in Soviet system in general, and Soviet law being so subjective and not always just and used as a tool to suppress society, sometimes there is a lot of doubts to the evidences collected by these trials, and for that reason it was decided when Lithuania was rebuilding its independent statehood, just to rehabilitate everybody who had a certain articles of Soviet criminal code as innocent. But today, as we collect more data, we realize that some of those perpetrators put on Soviet trials actually, for instance, did participate in Holocaust. And maybe there is evidences, and maybe those Soviet trials could be helpful somehow. But of course, you need to look to a very precision with the eye of a very experienced researcher to define these things, if there is evidence or not. So there is a lot of mistrust to those cases, and also this automatic rehabilitation harmed Lithuania, because, as I said, some people who were responsible, now historians think were a lot of evidence that they could be responsible for Holocaust, were treated just as a victim, and now to prove it, it's sometimes not easy. And also, another problem is lustration and the process of lustration, that again, very difficult to define who were those real perpetrators, and what level of collaboration is actually collaboration, because at some point many people actually belong to the communist structures in the late Soviet times, and it's another issue. And yeah, the current developments, as I mentioned, there are developments in administrative law banning those symbols, but also Lithuania is trying to to apply not only in the case of Ukraine, but also in the case of Belarus. For instance, Lithuania is trying to apply universal jurisdiction locally in local courts for political prisoners and political criminals that resisted, for instance, Lukashenko regime and became victims of that regime in Belarus, or in the case of Ukraine. So Lithuania is trying to also participate in those joint efforts, like joint investigation team. Again, my colleague Katerina is more expert on that, so I think she will tell more about the Lithuanian efforts. But yes, there is this consensus in the society that we should put efforts and try to help Ukraine as much as we can, because the Ukrainians courts and system in general, legal system, is so overwhelmed by those cases that it's sometimes difficult to do the job, and they definitely need the help of the other countries. So that's brief. If something was not clear, so I would be very glad to explain these things. Some things myself I still don't understand because the project is still ongoing. But me and Katerina Latish and Dovilė Sagatienė working as a team, trying to really do the best, not only to evaluate the situation of transitional justice in Lithuania and Ukraine, but also to give some kind of advice how it could be proceeded later to achieve the most possible justice for the victims. Thank you very much.
Thank you very much, Monica, for your presentation and for your overview of the Lithuanian situation. And I would like to remind you that questions we will take later, this time after 2 more presentations. And now I'd like to ask to speak Associate Professor Dr. Kaja Kowalczewska from University of Wrocław, and her title is Reforming International Criminal Law in Poland in Response to Russia's Aggression Against Ukraine. So, Kaja, the floor is yours whenever you're ready.
Yes, thank you. I hope you can see me and my presentation. Yes?
Yes, we do.
Perfect. First of all, I would like to thank to the organizers, especially Dovilė and Katerina, for inviting me and creating an event with such a body of experts that are discussing the topic that should be one of the priorities of public political and legal discussion in our region. This is at least my opinion. And I would like to say a small disclaimer at the beginning. Of course, I'm an academic, but here today with you, I'm under somehow a double chapeau of academic, but also a representative of civil society in Poland, as I'm coordinating the coalition of Polish NGOs documenting international crimes committed in Ukraine. And thanks to this experience, I can have some deeper insights into what is happening actually in Poland for last 2.5 years. And I would like to say that I agree with everything that was said before by other experts, that the issue of international criminal justice is such a complex and multifaceted problem, where we cannot forget, first of all, about history, about power struggle, and where actually, in order to bring the principle of complementarity into practice, we also have to take into account the support and efforts of civil society. And in my opinion, the civil society can somehow support the victim-centered justice, and despite the political challenges that our states can face in light of different prosecutions. So today, I actually want to show you what happened since the full-scale invasion on Ukraine, on the example of Poland, because I believe that universal jurisdiction and state national investigations are the key for more effective system of international justice. So as you probably know, Poland was the first one to open the investigation. Unfortunately, it was not that clear to us what was happening in the first year of that investigation because exactly of political situation in Poland. I will talk about it later, but thankfully, after 1 year and change of the government, we managed to start the dialogue with public authorities, with the prosecutors, and today I can tell you that the Polish investigation is based on, let's say, war crimes that you have listed here on the slide. But to be honest, the whole investigation is not really restricted to only those legal offenses. And what was very important is that there was a special task in National Prosecutor's Office created for the sake of this investigation. There are 5 prosecutors that are, let's say, delegated to conduct this investigation, and they have 2 assistants of prosecutors that help them. The problem is here that they are not solely responsible for these cases. The international crimes investigation was added to their daily schedule of prosecuting and investigating organized crime and espionage. So this is one of the challenges of the practical side of bringing the justice for victims of international crimes. They have also developed a network with the regional prosecutors as focal points, and they were assisted by Internal Security Agency, who was actually conducting interviews. Of course, this is all because Poland hosted in the first months after the aggression a huge amount of Ukrainian refugees. Some of them stayed. I know that now Germany is the country with the biggest number of Ukrainian refugees, but Poland is still in the top list of places where possible witnesses are residing. And luckily, Polish investigators also joined the joint investigative team for Ukraine and the ICPA targeting the crime of aggression. So I would like to share with you, before coming to the legal discussion, what is actually happening, what happened, and what are the challenges to the effectiveness of those efforts. So first of all, we know that our prosecutors try really hard to reach out to all the witnesses that can have valuable information for this investigation. So they reach out to civil society, to 22 organizations, although from what I know, none of them responded, and this may be due to the political distrust towards public authorities in 2022 in Poland. They also use some traditional and more innovative ways of reaching out to direct witnesses. So probably in your respective countries, you also have some kind of public alert system where a state can warn citizens about some extreme climate situation like floods or strong winds. So this system was the Government Center for Security was used to disseminate information for Ukrainian refugees in Poland. So everyone should have received a text message saying that there is an investigation and you are invited to share information if you want. And of course, there were also traditional leaflets and posters disseminated through law enforcement agencies. So what was the result of that effort? We know now in 2024 that the prosecutors managed to interview more than 2,000 people, something around 3,000, what I heard now. And out of those testimonies, they said that they can build 30 cases. Those are nevertheless possible cases because in Polish legislation, we don't have trials in absentia, and our universal jurisdiction regulation is pretty restricted. I will talk about it in details in a few minutes. But this is what we have now. This is what our Minister of Justice said in a recent interview, that there is enough of evidence to open those cases. So the question is why they are not opened, right? So I would like to also sum up the challenges of the last 2.5 years. So as I already mentioned, the previous government was not really a trustworthy partner for civil society, also for part of the population. There was no open communication about the developments, and there were only some press releases, but they were pretty generic. We know that apart from special task and this investigation that I'm talking about, Polish prosecutors and Polish police servicemen and other Polish law enforcement agencies were assisting Ukrainian prosecutors. They visited crime scenes, they shared the technology to collect evidence for future investigations. So there was, thanks to also to this JIT, some kind of international involvement and sharing of resources with our Ukrainian colleagues. So when so this political situation changed now, and I will talk about it in a second. But the second thing that we discovered as civil society, that the composition of this special unit was maybe not the ideal one, and it never is. But as I said before, this massive investigation with so many witnesses and so many evidence, it was delegated to people who as an additional task. So there is no special unit devoted only to that exercise in Poland. And what is more, Poland had, as it was previously presented by Dr. Rogers, some kind of investigations in the past about the communist crimes. But in modern Poland, after 90s, we had only one case of international crime. It related to war crime committed by our soldiers deployed to Afghanistan, and it was led by military prosecutor's office. And it was also highly criticized in a way that it was conducted. So there is no institutional memory in Poland, and I guess this is not only case of Poland, as how to conduct such investigations. There is no expertise in international criminal law, in international humanitarian law. There is little understanding on how international public law works. So our prosecutors had to start their efforts in a very limited conditions where they couldn't really use all the resources that normally should be there for investigators. And even though they managed, and I understand that what Yvonne said about the flexibility of international criminal law, that this may be a challenge, but it may be also be an opportunity, because investigators and prosecutors can get very innovative in how to use the existing legal framework to bring some kind of justice to victims. So this is what is actually happening in Poland, because the investigation that I show you here is of somehow auxiliary nature, or we can even call it structural investigation. So all the testimonies, all the evidence that was collected is in hands of our prosecutors. It's being shared with other prosecutors from, for example, Ukraine, but is not being used now for a specific investigation in a specific case. So this is on one hand a problem, because it's hard to justify the work of our prosecutors, like, you know, the resources, the time that was devoted to that from a legal point of view, because Polish legislation doesn't know the mechanism of structural investigations. But on the other hand, it shows like those moral, political obligations also play a role where our authorities try to somehow support those efforts in a way that is pretty creative. So the change that came this year with new government, and I have to say, if you don't know, that our Minister of Justice, Adam Bodnar, is he was previously a leader of Helsinki Foundation for Human Rights, so the oldest and the biggest NGO in Poland dealing with human rights violations. So he understands well what is the benefit and the contribution that civil society can bring to the table in this topic. So with the change of politics, There was also a start of cooperation with our coalition that was created in April. We managed to have some meetings, trainings with the prosecutors. This is why I also can share today with you those details. But the second important development is that Poland currently is not only conducting investigations in the field of international crimes only related to Ukraine, but also we have at least because it's really hard to map those investigations, 2 investigations connected with the Israeli-Palestinian conflict. So one about the Hamas attack on 7th of October last year, but the second also about the 1st of April this year, when the humanitarian World Kitchen car, the humanitarian aid workers were attacked and killed in Gaza, arguably by IDF attack, and the Polish citizen was killed. So as we see, and also now with the dynamic situation about the Lithuanian referral of the Belarusian cases to ICC, we may also face a new chapter. It means the Belarusian cases in Poland. So despite the fact that in the very past, after Second World War, Poland had a very proud chapter of the international criminal justice, then long time nothing, then just one case about war crimes committed by our soldiers. And then now, hopefully, we can contribute more to the whole effort of international criminal justice. So to do that effectively, we need reforms, many reforms. And I want to present today to you one of the reports that was created. Here you have covers of 2 of the reports that were commissioned by Helsinki Foundation for Human Rights. And those 2 reports represent 2 strands of the reforms that we as civil society, together with academics, we want to advocate for in Poland. The first one is the report In Search of Justice, which is about creation of a victim support system in Poland, because we cannot forget, like, now everyone is saying survivor-centered justice, but we cannot forget that this justice is not only about the court ruling and this court-proof justice. It's all about the protection of human dignity in the process and in the time when the whole investigation is taking place until the end of the trial. So normally it can be even decades. So Poland doesn't have any working public victim support system. And I know, again, that this is not only case of our state. So Helsinki Foundation wants to really push for that kind of reforms. So people who are not able to work, who are not able to socialize that easily in the new society where they were displaced to, whether they can really get the support they need, and it's about medical, psychological, legal, and social support. But I want to talk about this today. I will focus on the report in the red frame, the report about the needed reforms in legal framework to make our investigative efforts more effective. And I have to also mention that apart from the civil society input to the whole discussion in Poland, we also have 2 bodies that were created by MOG in Poland in the whole move of updating our Polish legal system after the years of manipulation by previous government. So there are 2 codification commissions that are very relevant for our today's topic. One is the Codification Commission of Criminal Law, and the second is for the system of the judiciary and public prosecution. So as the first commission is charged with the changes of substantive and procedural law, the second one is charged with the organization of the whole judiciary and especially prosecution. And the good news is that those codification commissions, they are open to the dialogue with experts from civil society as well. And one of the authors of the report on effective investigation is also my personal boss at the University of Wrocław, an amazing scholar and woman, and she's also a vice president of the Codification Commission for the System of Judiciary. So we are really hopeful that that cooperation will bring really permanent changes and tangible changes. So I want to shortly present you today what is needed in Polish jurisdiction to make those investigations more effective or even possible. So here is the overview of our report created by 5 excellent academics, all women, in which we divided our work into 5 chapters, and out of which we presented 66 recommendations that should be taken into consideration by the legislator when they're gonna change criminal law, not only for the reasons of international criminal justice, but also the normal reform of internal and national legislation. So as 66 recommendations are not possible to be presented in a time that is left to me, I will just focus on the main recommendations, main takeaways from each chapter. So the first one was about the international obligations of Poland. And here it was highlighted that it's not only the matter of political choice, but also a legal choice, that the prosecution of international crimes should be a priority for our government and public authorities, because a lack of such prosecution can result in negligence and in international responsibility of Poland. And this is the case of majority of states on this planet. So I'm sorry, oh yeah, it's working. The second thing is that Poland, and I have to say that Poland is rather, let's say, active in terms of number of ratifications of different treaties that are related to human rights and international criminal law, but still there are some gaps that we wanted to outline. So it's the ratification of amendments to the ICC statute and the International Convention for Protection of All Persons from Enforced Disappearances that need to be done in order to really close the gaps in our legal systems and provide legal pathways for victims of that kind of crimes. Again, for effective investigation, the current process of ratification of Ljubljana Hague Convention on Mutual Legal Assistance is ongoing. This treaty is still not in force. It needs only 3 ratifications to start, be operative. So I guess this is something that all countries that say that they care about international criminal justice should do, as well as Poland. And of course, we also argue that Poland should get engaged in the, on one hand, the amendments to the ICC statutes, especially when it comes to the new definition, hopefully new definition of crime of aggression, but also the work that is being conducted at the UN Forum for Convention on Crimes Against Humanity to really close the gaps in the system. When it comes to substantive criminal law, and this is something that Thomas tried to answer, and something that I guess is still not very specific for Poland, but for all, at least countries in our region and in Central Eastern Europe, is that our domestic legislation is not comprehensive in terms, it's not fully aligned with the definitions of those core crimes that are in the treaties. So what we advocate for is a comprehensive policy and law reform when it comes to the provisions of the criminal code, especially for correct classification of types and definitions of those crimes. And this is also something that our colleagues from Ukraine know, that it can be a problem once it's too late and the armed conflict is on our soil. And in general, all the chapters about international crimes should be reviewed, because in many cases, the criminal sanctions that are there are very low. And this is, again, something that Yvonne said, that once we see that at the end of the process, a perpetrator can be sentenced to 3 months in prison, and while the whole prosecution and the trial lasted several years, costed several millions of zlotys or euros, I guess this is something that runs against the raison d'etre of that kind of prosecutions, and every citizen would probably oppose that. So those criminal sanctions should be revised, the definitions, but also in order to make it real and effective, the national legislator should also think about engaging international law experts into the update of the Polish criminal law, because as we know, there is this huge struggle between being a criminal law lawyer and international lawyer, and then when they meet where they meet is international criminal law, and there are different perspectives, and it's important to consider them all. So then, very important point, and the chapter about exercise of universal jurisdiction. Sorry for the title was cut. So what is the current state of affairs in Poland? First of all, the provisions of our criminal code of procedure are very unclear, even for experts. It's really hard to understand what are the current conditions to start a universal jurisdiction proceedings. So there is a discussion what can be done at the moment when the perpetrator, the suspect is not present on Polish soil. So one more restrictive and apparently supported by our Minister of Justice interpretation is saying that we cannot even start the preparatory proceedings and issue the charges when the suspect is not on Polish soil. The more expansive interpretation, the one that can be done, but of course without political will of the public authorities that are supervising prosecutors, it won't work. But it is that we can actually start preparatory proceedings, present charges, issue them, and start international search for the suspect. So that kind of interpretation gives us more field to work and can send a stronger signal that those accused and suspects cannot go unpunished, and there are countries that are investigating their cases. Also, in our report, we recommend that the application of universal jurisdiction should be allowed when the perpetrator is not present on the Polish territory, because currently, and unlikely like in a UK case, currently it is enough for our Polish prosecutors for the suspect to be present at the territory. So there is no requirement of the residence. So if someone is just flying through the Warsaw-Chopin airport, and he can be caught. But that is our recommendation, that we should expand that in universal jurisdiction to allow for more cases to be done. And when it comes to trials in absentia, currently they are not allowed in Poland. Although, again, and in Lithuania, our Minister of Justice said in September that he is open to the discussion about in absentia trials, although because of certain challenges that were also mentioned today, we are rather skeptic about this kind of solution, and if needed, that kind of trial would really have to be scrutinized against the requirements of ECHR jurisprudence and EU law in order to uphold the fundamental principles of right to fair trial, to defense, to information, and possibility of reopening the proceedings once the sentenced person is back on the territory. And the two last chapters, the one about organization of the prosecution, what should be done to create a space and resources that are needed for effective conduct of investigation, is to establish a specialized permanent organizational unit at different levels, starting with National Prosecutor Office and also in the lower levels of law enforcement of police units and prosecution units. This is all coming, of course, from the challenges I described before, of lack of institutional memory, lack of expertise. And what we actually recommend is to have some kind of special trainings on ICL, IHL, human rights. The people who are in those units should have some basic language skills. English is a must, but other languages, especially from our region, should be also included. And we also want to add to that the recommendation about interdisciplinary character, because we know that those kind of investigations are pretty specific, and the cultural context, the traumatization of victims, those are the factors that need to be taken into account, and which are not in the mandate of lawyers, prosecutors, who are not experts in that, but could cooperate with experts like anthropologists, cultural experts, gender experts. And of course, we have to know that the ICL, IHL, human rights, international law, those are the subjects that are not mandatory in legal education curricula in Poland. So we really see a huge gap among practitioners, attorneys at law, prosecutors, and judges. So that's a huge obstacle. So the third recommendation is, of course, to expand the cooperation with international actors with broader experience. And my last chapter is the one that I had the honor to offer, and I will just go quickly through that, is to, of course, develop some kind of two-way trust-based communication, cooperation with civil society, provide specific trainings on how evidence can be collected to support efforts of investigative bodies. We need also those specialized trainings for the whole support system for victims. And this is all to avoid risk of over-documentation, overflow of evidence, and re-victimization. And I will leave you with maybe a hope, because this is just the beginning of the work, and it's going to be continued. Next month, we have two events. One is the conference which we organized together with MOG, where prosecutors from Poland and Ukraine will be present, as well as international experts, where the recommendations will be discussed. And the second one is the workshop on universal jurisdiction in Poland for legal practitioners and NGOs that wish to be engaged in the universal jurisdiction training. So thank you for that, and sorry for time discipline. Thank you. Looking forward to the discussion.
Thank you very much, Kaya. I would like to appeal to other presenters. Please keep the time limits, because I know that all of you are have a lot to say. But anyway, we have some limits, and we need to keep them. So now I would like to invite and to give us a presentation Associate Professor Dr. Gayane Nurijanian from the Faculty of Law, UIT, the Arctic University of Norway. So Gayane, please, the floor is yours, and please follow the time. Thanks a lot.
Thank you very much, and thank you to the organizers for inviting me to join the event. It's my honor to be among such distinguished colleagues and experts in international criminal law. I will talk today about actually importance of justice for international crimes committed in Ukraine. So we heard that International Criminal Court may not be working. We have arrest warrants from the ICC that are not being respected by the state parties. We have decisions by other institutions, other international courts that are not being enforced by the states. But despite these challenges, why justice still matters and why it should be pursued, especially for the crimes committed in Ukraine. And before I address that issue, I would like to provide a brief overview of different justice efforts that are now being pursued in the situation of Ukraine. And broadly, I could divide these efforts into three categories. The first one is directed at bringing to accountability individual perpetrators of international crimes. The second one relates to the accountability of Russia as a state. And the third one is directed at ensuring the reparation to the victims for the harm that is suffered as a result of the war in Ukraine and international crimes committed during that war. So turning to the first point, the individual criminal responsibility, of course, the most active perhaps actor here is domestic courts in Ukraine. So now there may be around over more than 100 judgments related to specifically to the war crimes committed after Russia's full-scale invasion in Ukraine. And we heard from other colleagues today that domestic courts face challenges in applying correctly international criminal law and definitions of international crimes. And that has been a challenge for Ukrainian courts as well. So Ukrainian courts, as well as prosecutors and investigators, have to generate and build up competence and expertise in prosecuting and trying international crimes. And that has been perhaps the main challenge for the Ukrainian criminal justice system lately. But we also see that it's done with cooperation and participation of international experts that is quite helpful. We don't see a lot of proceedings or verdicts that relate to the crime of genocide yet in Ukrainian courts. The latest case actually is an in absentia conviction for the public incitement to genocide. But according to different information available for public sources, there are around 30 cases pending and related to the charges of genocide. Ukraine's, until very recently, or one could say still doesn't have crimes against humanity in its criminal court, but you may have heard that Ukraine is in the process of ratifying the Rome Statute. And as part of this process, Ukraine is also changing its domestic legislation to include crimes against humanity. So this will be another challenge for Ukrainian judges and Ukrainian criminal lawyers who work in Ukrainian criminal justice system, understanding what are crimes against humanity and applying them correctly. But nevertheless, this category of the crimes will actually, in my opinion, allow to capture the special side or some special character of the crimes that are being committed against population of Ukraine, and that is actually that the acts are committed as part of widespread and systematic attack against civilian population. We've also heard that there are proceedings pending in domestic courts. Most of them are of so-called structural character. In Norway, where I work, the special police unit also has reached out to Ukrainian refugees and has tried to collect that information that may be helpful for prosecution of international crimes, but there are no cases actually against specific perpetrators pending in Ukraine. This information that is gathered from Ukrainian refugees who are possibly witnesses of international crimes is shared either with Ukrainian authorities or with the ICC. For example, one interesting development here is the arrest of Jan Petrovsky in Finland in 2023, last year. And his case concerns actually not the crimes committed during the full-scale invasion, but back in 2014 when the war actually started. And now the investigation in his case, he is suspected of committing war crimes in Ukraine, has ended, and by the end of this month, October, actually the prosecutor has to decide whether to bring this case further. So that could be a perhaps first case where we see a perpetrator prosecuted based on the universal jurisdiction principle. Then, of course, we all know that the International Criminal Court is also involved in the effort to bring the perpetrators of international crimes in Ukraine to accountability. There are 6 arrest warrants that have been issued by the court. They concerned war crimes and crimes against humanity. You perhaps know that the first arrest warrants were issued in connection with the crime of unlawful deportation of children from Ukrainian territory, and later arrest warrants, they focused specifically on the attacks against civilian infrastructure and energy infrastructure in Ukraine, and these acts are qualified either as attacks against civilian objects or attacks that are causing incidental excessive harm to civilian objects or civilians, but also as crimes against humanity. There are no charges that relate to the crime of genocide or crime of aggression before the International Criminal Court. It's not excluded that the acts of deportation of Ukrainian children from the Ukrainian territory may in future be qualified under the charges of genocide, because forcefully transferring children from one group to another and re-educating them, subjecting them to re-education that aims to erase their national identity, their cultural identity, can constitute an act of genocide. So it remains to be seen how the prosecutor at the ICC will handle these acts related to forceful deportation of children. But as many of you know, the ICC doesn't have jurisdiction to prosecute the crime of aggression specifically committed in the situation of Ukraine. And that's why another aspect, another effort at obtaining justice that Ukraine is pushing forward is the creation of the special court, a special tribunal for the crime of aggression in order to ensure accountability for the crime of aggression, which is basically the act of starting a war in breach of international law rules on prohibition of use of force. We haven't heard much about the latest developments on this front. The latest option that was discussed with regard to special tribunal is creation of a tribunal based on an agreement with the Council of Europe, so a regional institution. I will return to this issue of the special tribunal when I talk about importance of justice, because this is one of the bringing political and military leadership of Russia to accountability for the crime of aggression is quite important for many reasons, as I will address later. The justice efforts on Ukraine are not only directed at bringing perpetrators of international crimes to accountability, but also to bringing Russia as a state to accountability for violations of international law. There is no international judicial fora where Ukraine could actually raise an issue or bring a claim against Russia for the act of aggression, for unlawfully starting the war against Ukraine, for using force in breach of the prohibition of use of force. But Ukraine has chosen to actually litigate issues related to violations of human rights and other international law that are committed in the course of this war. And here there are two institutions, two international courts that Ukraine has appealed to. The first one is the International Court of Justice, and Ukraine has brought two cases against Russia before this court. The first one is concerned with the application of International Convention for the Suppression of Financing of Terrorism, and the other one, another international instrument that is litigated here is the Convention for the Elimination of All Forms of Racial Discrimination. And this case was decided on the merits by the court, by the ICJ recently, and I must say that the result, the outcome here has been quite disappointing. In my personal view, the court has taken quite a formalistic approach, especially when it comes to the issue of racial discrimination. So the court, the ICJ, found on violations of these instruments only on very limited grounds. When it came to the question of racial discrimination of Crimean Tatars in Crimea and Ukrainian ethnic population in Crimea after Crimea has been annexed by Russia, the court basically said that these groups were persecuted because of their political views, but not because of their because they belong to a different race or because of their ethnicity. And in my opinion, that position ignores actually that this concept of intersectionality, that sometimes there can be more than one grounds on which a group or a person is discriminated against. It's important to say here that having found these violations in the case, the ICJ stated that declaration of violation itself was a sufficient relief. So in these cases, the Ukraine did not actually receive any compensation for the violations of these two conventions. And this is important when I come to talk about the reparations and what reparations regimes there can be for the victims of the crimes and human rights violations committed in Ukraine. The other case relates to the allegations of genocide under the Convention for the Prevention and Punishment of the Crime of Genocide, and that case was brought against Russia several days after the full-scale invasion in 2022. And here Ukraine basically claimed that Russia used false allegations of genocide to justify its military actions in Ukraine. In this case, the ICJ also came to the conclusion that its jurisdiction is very limited and it's going to look only into the issue that there are no evidence that that genocide was being committed in Ukraine, but it's not going to examine actually the issue whether Russia's actions and Russians' false or bad faith use of the convention in order to justify its unlawful use of force are actually in breach of the convention. And that's important because it also suggests that there is very little possibility for Ukraine to get a compensation and reparation for the damage that is caused by Russia's use of force. There are also several cases pending before the European Court of Human Rights, which I will not go into detail, but here the problem is that even though ECHR, European Court of Human Rights, takes much more closer look on what is going in Ukraine, both in Crimea and in Donbass. The court recently has found a number of human rights violations that were committed in Crimea by Russia, but the issue here is the enforcement of these judgments. Interstate judgments before the European Court of Human Rights are notoriously very difficult to enforce. The respondent states usually do not enforce them. And another problem here is that after its expulsion in 2022, Russia does not really engage with the Council of Europe and the court. And why I'm talking about the difficulties of obtaining compensation is in these interstate cases before the ICJ and ECHR, is that in my opinion, it is very right that other efforts are being made to ensure that the victims of international crimes are provided with adequate reparations. We cannot, in this respect, to expect relief from the ICC on the reparation stage or from the international courts is going to be a distant prospect. So it is very important that Ukraine and other states are working on a different mechanism for providing reparations to the victims. And here I'm referring not only to the efforts that are actually made in Ukraine, within the legal system of Ukraine, to provide people, especially with compensation, especially those who have lost their houses and their homes, but also the creation of register for the damages caused by the Russian aggression in Ukraine, which is the first step to creation of the compensation mechanisms that will be composed of this register that collects and records the evidence related to the harm and damage suffered, then a claims commission that will look at this claims and decide eventually who receives the compensation and in what amount, and then the compensation fund that is going to form the basis for the compensation. It is obviously going to be a long process. Recently, the executive director of this register of damages said that they expect several millions claims to be received within this system. But nonetheless, and now I'm turning to this point about why the justice is important, it is an important effort, a significant effort to ensure justice for the victims of the international crimes committed in Ukraine. My impression is that sometimes in academic discussions, in the discussions of political issues arising in the situations in Ukraine, on the creation of the special tribunal, functioning of the ICC, actually the main purpose of why this mechanism exists is sometimes being lost. And I think these mechanisms exist in order to provide justice to the victims, to very concrete people who have suffered harm. They have lost their loved ones, they have lost their houses, their livelihood, they had to move to a different country to live for years in a state of uncertainty, not knowing whether they will return to Ukraine or not. And in that respect, I think just the recognition before the international courts that they have suffered damage, their rights have been violated, is very important to them. The war has inflicted a very profound sense of unfairness and injustice on people in Ukraine, and here obtaining the recognition that yes, we condemned people who have caused the harm, who have inflicted this unfairness on you, is very important for the victims. But there are also different conceptions of what is justice. For some, bringing to responsibility leadership of Russian Federation is not enough. Many in Ukraine want to see concrete perpetrators, direct perpetrators, brought to justice. For others, that is not sufficient, and for them, compensation of the harm is important. And that's why here, not only the proceedings before the ICC or in different, before domestic courts, on courts in other national jurisdictions are important, but also the creation of this compensation mechanism that will be independent of the outcome of these different proceedings, or independent of the political will of the respondent states. Second point of why I think the achieving justice is very important despite the different obstacles that Ukraine is facing is actually upholding the rules and principles of international law. Perhaps that sounds quite trite and naive, but in my opinion, the lack of accountability for international crimes, and especially for the crime of aggression, can have very negative consequences, not only for Ukraine, but for international community. And we've seen that already in the situation of Ukraine. Lack of proper response to Russia's invasion into Crimea and Donbass in 2014 actually, in my opinion, led to the escalation of the war in 2022. And the fact that there still hasn't been effective enough response, for example, in creation of the special tribunal for the crime of aggression, means also that Russia is being able to wage this full-scale war in Ukraine for the third year in a row. Not to mention that that may have also contributed to the escalation of conflicts in other parts of the world that we witness now. And then my last point here, and I will be ending my presentation here, last but not least, that actually different cases and proceedings before international courts and tribunals contribute to countering Russian disinformation. Russian war against Ukraine is not only taking place on the battlefield, it's very much the war of narratives, the war of middling the reality, trying to create a situation where who is right, who is doing what is uncertain, and building their support on this fog, informational fog and propaganda. And here we've seen that proceedings and decisions of the international courts can actually dispel the fog of war. I have several examples here, and we can discuss that later, but one interesting example is actually the decision of the European Court of Human Rights in Donbass cases, Ukraine and the Netherlands versus Russia. For many years, since the war started in Ukraine in 2014, there was quite unclear for the outside world what was actually going on in the east of Ukraine. Are we talking about the civil war? Are we talking about genuine separatist movement? is Russia really involved, to what extent? And that even affected the qualification of the situation of under international criminal law, whether international armed conflict or non-international armed conflict. But last year, the European Court of Human Rights came up with this decision and said, look, we have evidence the Russian military forces were in Ukraine, in Donbass already in April-May 2014. And actually the whole separatist republics and groups that exist in eastern Ukraine have been supported, cultivated, managed from Russia from the very beginning. And I think that's a very important decision that, based on thorough examination of evidence, counters Russian narratives and disinformation. I will stop here. Thank you for your attention.
Thank you very much, Gaian, for your wide presentation and a very detailed overview of international status with the jurisprudence and I'm sorry, and all the other issues related to the responsibility. So after some thoughts, we decided to continue with the presentations and to leave questions at the very end, just because to align the time. So now I would like to ask Associate Professor Dovilė Sagatienė from Mykolas Romeris University to present her presentation on problem of genocidal intent, a historical perspective for Ukraine. So Dovilė, the floor is yours.
Okay, thank you so much, dear moderator, for presenting me. And probably it would be okay if I will limit myself to 10 minutes. Yes, that will be fine. Just to catch up with the time, because I think what we already talked, some of the issues can be repeated, but no need to repeat them already, so I can really limit myself. I will gonna talk about the problem of genocidal intent, and especially about the historical perspective for Ukraine from Lithuania, because Lithuania already did some work, I mean, on international criminal law field, how to prove genocidal intent for Soviet crimes, previous crimes of Russia during the Soviet occupation. And really, my publication and presentation tries to go deeper in that, how it was done. So probably you all remember 2022 April, and these are the photos from Bucha. And you know that at that time, there was a peak of political declarations about genocide happening in Ukraine. But my question is, not the question, but the problem is that political declarations are not enough to declare that there was a genocide. We all know as lawyers that should be, certain legal elements proved. And really, Ukraine is still struggling with that issue. But not because the lack of the evidence, but probably because of the overload of the evidence. So I will try to structure how Lithuania dealt with this problem of genocidal intent of Soviet crimes and how it could contribute to Ukrainian cases. So let me just state a little bit that, of course, I'm not talking about individual responsibility here for genocide. Main question I am targeting here, the perpetrator state's plan to destroy a national group in whole or in part, as established in genocidal declarations or in speech. So, like, basic question, bottom line is there genocidal plan by Russia for Ukraine? Is it or not? So let me just go to my next slide, and why genocidal intent is so crucial, and probably the main legal element of proving genocide is because genocidal intent really shows the targeted group. Is it national, ethnic, racial, and religious? Because, in general, genocide is very collective, the crime of collective nature. It protects the group, not individuals, but the group, and protects group as such. So really, the case law so far, international case law so far, emphasized that genocidal intent can be interfered from systematic large-scale atrocities. particularly when directed against specific group. Even there is an absence of like written and direct statements and written plans to commit genocide, because really you cannot find anything, you know, even in Nuremberg trials, you cannot find, you know, that Hitler signed a plan of genocide or of killing Jewish people. So really this is very, very, how to say, complicated issue of genocidal intent. So what are actually the actions by Russia? Probably, let's say like this, what Lithuania did in the cases before the European Court of Human Rights, in Drelingas case specifically, and Vasiliauska's case, about trying to prove that some Soviet crimes against Lithuanian partisans as a group, yes, partisans is a part of national group of Lithuanians, some crimes against Lithuanian partisans by Soviets could be recognized as genocidal acts. So what Lithuania did, of course, Lithuania was proving that partisans were genocidal targets, that they were targeted because of the crucial role in surviving of a nation. Because, of course, partisans, they were representing the Lithuanian state under Soviet occupation, and that was the crucial part of Lithuanian statehood to survive. And it's even established in Lithuanian law that was the real representation of real Lithuanian nation and statehood, the partisans, not the Soviet occupational power. So Lithuanians targeted that. Then what they did, Lithuanians made a link between Soviet ideology and genocide, because as I mentioned, there was no, you know, like direct plan signed by Stalin or Lenin before Stalin or the leaders afterwards to commit genocide against Lithuanian nations, because, you know, it couldn't be. And really Lithuania needed to show what was the goal of Soviet ideology, what was the goal of the Soviet regime in the occupied countries. And of course, we were succeeded in the second case of Drelingas case to prove that really the plan of Sovietization included systematic repression, the elimination of national resistance, the destruction of Lithuanian political and social structure. And those officers, Soviet officers, who were participating in arresting or killing Lithuanian partisans were actually committing genocidal acts. So proving Russian genocidal intent in Ukraine, what is crucial to do? Of course, we can look at the public genocidal declarations. There were many. And, you know, there were February 2022 speech. Then before that, there was Putin's article of July 2021. Then there was a piece on RIA Novosti, what to do with Ukraine. And there was a Medvedev's also Telegram post. So there were many of very high official declarations about how Ukraine is not the real state, Ukrainians are not real people, and, you know, somehow Russia needs to solve this problem because, you know, Ukraine has no agency and no right to exist. So this is already very, very, how to say, surprisingly direct speech, surprisingly direct genocidal speech. But linking state ideology and genocidal acts may also be very crucial. And then there is the question, which is main for me, what is the state ideology now from Russia, of Russia to Ukraine? Not only to Ukraine, but in general, what is the structure of Russia? Who is making decisions? Who is, you know, what is the content of their thinking and mindset? So we know those, you know, influencer thinkers like Ivan Ilyin and Alexander Dugin, who were, you know, for the past 20 years, they were trying to develop that ideology, which now is like called ideology of Russianism or Russian fascism, a mixed ultranationalism, personal cult and expansionism, but still it's not settled and it's not very clear. So as the cases of Lithuania at the European Court of Human Rights shows, that might be crucial and might be requiring to include political science experts. Also, you know, to understand what is the decision-making procedures within the state and what is the main ideology of Russia at the moment. Is it totalitarian state? Is it authoritarian? Is it fascist state? Nobody really knows the term yet, and we are still coming to terms in this regard. So thank you. I hope it was not too long. I think I managed in how many minutes? 19?
Okay, 8 minutes, 40 seconds and counting.
Oh, okay. So that's a record. Fantastic.
Okay, thanks a lot. Thanks a lot, Dovile. Yes. So now then I would like to pass the floor to Associate Professor Katerina Latish, who is from Mykolas Rometz University Memory and Justice Research Center, as well as from Yaroslav Mudry University of Kharkiv, Ukraine. So Katerina, the floor is yours, and then we will switch to the discussion. Thanks a lot.
Thank you so much for presenting me, and I will proceed shortly with the genocide case in Ukraine and experience of achieving justice in that circumstances. And as far as during this brilliant roundtable, we discuss not only a legal point of view, but also from historian perspective and also from memory law. I will start initially with the first case of genocide, which was committed in Ukraine. And this one is about Holodomor. But before I will jump to it, just try to say regarding the plan, what I'm going to cover. Again, as a Dovile, I will try to do it shortly due to the time constraints. So basically, I will start with a Ukrainian local case study, Holodomor as genocide. We didn't have in Ukraine it in the international level in the European Court of Human Rights because it was not appealed, but I will tell you more about it shortly. Then we will discuss regarding the situation which is going on now regarding again whether it was genocide or not, what's going on now, and we'll speak about it also in accordance to case studies. And of course, the third one, the case in the ICJ regarding the allegations of genocide under the convention, which is still going on, but still it's very interesting and very creative how Ukraine tried to use it in this justice battlefield, let's say like that. So regarding the first issue, regarding the first case which we had in Ukraine, it's a Holodomor case, and it's true that, as Professor Andrea Graziosi told, that in the let's say breadbasket of Europe, it was committed this horrible crime, and regarding the Ukraine strategy to prove it, again, it should be mentioned that it was two levels, judicial one when the local appeal court considered it, and also political one because before the political will appeared, it was not even any kind of investigation regarding this case, only some kind of historical or legal researchers trying to do it mostly even abroad, not even in Ukraine. They collected a lot of materials. There were some films filmed regarding that. But at the same time, it took like more than almost 70 years to settle some kind of justice, as we see. And basically, as I said, it didn't reach a high level such as the European Court of Human Rights. It had only one stage of court consideration in Kiev. Again, it was closed because, of course, it was against main political leaders such as Stalin and others. So, of course, because of they were died, again, it was closed. But at the same time, the court, the judges, they considered different evidence which were collected in these circumstances, and I will tell you about that in a minute. So again, they gave their evaluation of each evidence, and they see that these persons were guilty. And why it was important? Because again, it created some kind of legal basis, or we could say even precedent for further political and diplomatic work at the international level, because then we see that many countries at the level of the parliament level, they try to they condemned this Holodomor as most of them as a genocide. And again, in the framework of memory, I think it's very important for victims not just receive a court decision, especially when it has some kind of symbolic way, but of course it's very important that as much as possible countries and people will know about this crime, because in some point it could also try to prevent it in future. And regarding the timeline, again, as I said, only when the political power changed in Ukraine, when President Viktor Yushchenko came, there was the law adopted regarding that. Then was initiated the court consideration in Kiev, and so you could see a timeline how it was, and actually it was 5 years. It took 5 years to come to the court verdict. And regarding the evidence, because it's also very important in this ongoing situation in Ukraine to see how we should collect evidence, what kind of evidence should be to prove the intent, genocidal intent, which Dovile told us a lot how it's difficult, and I think it's also very important to see in the case studies, different case studies, even in the local level, how what kind of approach was successful, and what kind of lessons learned we could take from that. And actually, here we could see what kind of evidence were used. Here we could see that 174 investigators in 70 regions participated in that. They collected information on in different archives, even in Russia, and they also a study is collected by historians, and in these circumstances why our project is very important as well. And then, of course, we should mention testimonies of witnesses which were interviewed both in Ukraine and abroad. And I think that Kaya very well introduced what kind of recommendations should be made in these circumstances, especially when we have a lot of work with civil society who interviewed the witnesses, the victims, and so on. And it's very important to comply with the requirements. Then export documents also were researched regarding the export of grain from the country in these particular years. And of course, death registration books, how many people were died, and as well as criminal cases against the Union for the Liberation of Ukraine. And the main aspect here, which I would like to mention as well, which is from my perspective, is development, maybe may call it forensic science reports, which were conducted in this Holodomor case to prove the intent, the genocidal intent, and all other elements of this crime. So there were plenty of forensic sciences report. Some of them also were conducted with involvement of scientists, historians, and you could see what kind of special knowledge were used in these circumstances. Especially, it was hard to estimate how many people were died because of the Holodomor due to different reasons. I will not go deeply on that, but again, in these circumstances, to prove this kind of issues, it would be very important to use forensic science to prove it. And one more thing, again, very shortly regarding the preparation for the genocide, it should be mentioned, and we should think about it, whether we could consider propaganda as one of the initial stage of preparation for the genocide. And for example, in Ukraine, again, since the war actually started in 2014, our criminal code was changed. There was added the article regarding the propaganda of war, and because it's also some kind of preparation for the genocide. And again, because it's not an impulsive act, it requires careful planning and mobilization of resources. And from the case studies in Rwanda, Nancy, and even in Ukraine, some of them also Dovile mentioned, we could see that it could be evaluated like that, and it also could be one of the evidence to prove this genocidal intent. And for now, we could say even it's also information for thinking whether we could say that this Holodomor is continued and prolonged crime, because even now we could see that situation when the starvation using as a warfare tactic in Mariupol, and there is a very nice report, nice from perspective of collection of evidence. Of course, I mean, then when it was a 12 months investigation, and they collected a lot of evidence which prove that Russia forces used starvation as a warfare tactic in Mariupol. And what is also very important to say that the report analyzes satellite images, videos, and other digital data. And for that reason, I asked Yvonne about, because she is a brilliant expert in this particular sphere regarding the user-generated evidence and information collected from open source, and what kind of recommendations could be for prosecutors, because it's not enough just to rely on the reports from different actors, even new actors for Ukrainian situation, because we don't have any kind of regulation in our criminal procedure code how involved this information, I mean these reports as evidence. Anyway, there are some creativity, but again, it should be mentioned. Here, some examples, you could read it more using this QR code about this situation which I mentioned. I will not stop about on that. And the last thing regarding the ICJ case, again, it's going on. And what is also worth to mention that it's very important how many countries made intervention in this case, and Lithuania was one of them. Lithuania made declaration in 2022, but then it adjusted just this year, and it also shows the very important role of Lithuania in these circumstances, and also regarding the prosecution of war crimes crimes and crimes against humanity, crimes of aggression, which Monica Rogers mentioned regarding the joint investigation team, because Lithuania was one of the first countries who initiated an early beginning of the full-scale invasion, creation of JID. And also it should be mentioned regarding the digital information and from evidence point of view again, that another task force investigation team which was created regarding the OSINT specifically collected this kind of information, which also shows the importance and this kind of evidence and standards which should be developed to collect this kind of information. So very shortly, this is what I wanted to say. Thank you for your attention and look forward for our fruitful discussion. Thank you.
Thank you very much, Katerina. So we still have some time for questions, and indeed, I think we've had a lot of important and interesting presentations, and well, we reviewed from the national to international issues. So maybe we have. I'm looking at the YouTube translation. YouTube translation is still without questions. So then I'll open the floor for all of us here. So who would like to, yes, to give a question? And yes, Thomas, please.
Okay, well, thank you. I'm wondering about the genocidal intent. Of course, I listened to Dovile Sagatien's very interesting remarks on that. But the question is, how far does the intent to destroy actually extend? One aspect, of course, is the issue of cultural suppression or suppressing a culture of a nation. If you leave the people alive but take away their culture, I think there is some debate on that. But maybe more interesting or more difficult is the question whether genocidal intent can also mean denying an ethnic group statehood. Is that already, I mean, you leave the group physically intact, but say we will integrate you into our state. Is that a genocidal intent? Of course, this does not only, as you know, come up with relation to Russian aggression, but also, of course, in the Israeli-Palestine conflict. Yeah. So it's a very difficult question, and I wonder what you are thinking about that.
Thank you, Professor, for your question. And if I may, on genocidal intent to refer first. So on cultural destroyment, how important that is it, does genocidal intent extend to this? So we should remember, firstly, how the concept of genocide was created. It was created before, by Lemkin. It was created in 43 through 32, so even before Nuremberg trials, but it was not used in Nuremberg trials, not yet, because it was not still, a genocide convention, because the genocide convention was adopted not only in 1948. But how Lemkin understood genocide really had very, very strong element of cultural belonging. Like if you are targeting certain group for which is, not abstract, you can define it on ethnical, national, cultural terms, it's already genocide. So it was very, very broad concept of crimes against certain group, because the logic of Lemkin, Raphael Lemkin, who is, by the way, from Lviv in Ukraine. He graduated there law school before the war. So he had very broad concept of genocide, and he was saying like this, that if you are targeting certain part of humankind and destroying certain part of humankind, destroying its culture, destroying its habitats, destroying its means to survive, you are destroying the part of how to say, global heritage. humankind is losing something very important if we are, destroying some parts of humankind, including in cultural terms. So I think, of course, that very, very broad concept, it couldn't pass to Genocide Convention because, it was impossible to pass it to Genocide Convention. Even social and political groups were excluded in the final version of Genocide Convention in 1948. So really, it depended on the powers of a states to agree and to balance the concept. And what about the Israeli and Palestine conflict? Really, I must confess, I am really not the expert, because I am not the expert of the, how to say, the cultural context, because really I know very little. The messages are very mixed and very confusing, and you really don't know which way to go. So I would refrain myself from this, like evaluation, because really I think there should be people who really understands the cultural background there and the history more than I do. Thank you for the question, by the way.
Okay, Dovile, thanks a lot. We have one question on YouTube, so I would like to ask this question, even though this is more of, I think, history and distribution of the knowledge. So Tatiana Boryak is asking how to present the results of analysis on Russian ideology. There are a number of researches by historians on the topics, but historians are not heard and ignored. Should one more book, but in English, be published? How to present historians' research results for prosecution of crimes of Russian Federation? So maybe I'll try to rephrase the question in a way. Can historian research results, maybe published in books and in other sources, could be held as a, let's say, as an evidence, maybe, during the prosecution of crimes in the case of Russian Federation and maybe in other circumstances? So maybe someone would like to react to this question. I'm a little bit looking at Ivone, maybe at Gayan. So please, who wish to take this question? Thank you.
I could start. Again, to address it with the case in Holodomor, because again, as I said, it passed a lot of many years, and only which we had its only materials from historians, and it was used by forensic science experts who were doing historical forensic expertise, and they were like a team of experts which also involved historians who had who meet qualification on that, and they analyzed this kind of materials and presented as a forensic science report on different issues, for example, on historian. It was in Ukrainian case and Holodomor case, and actually I had books where like examples of these forensic science reports, and court rely on that very much, and I think it was a good development in these circumstances. But I'm not sure how it will work in international criminal court. Maybe one could comment something about that, but I think it's quite a new practice in these circumstances regarding the historians' materials, and I pass the floor to Monica.
Yeah, I can only answer this from the national level. I'm not an expert of international one, but when I know it from my personal experience, when I was working at the Genocide and Resistance Research Center of Lithuania, which is basically historical institution and memory institution, not a legal one, but we would get a request from the prosecutors to explain some historical circumstances, to provide archival materials and so on. So in Lithuania, in national level, these historical evidences are included, and also KGB so-called KGB files, even court court files of the former political prisoners that has sometimes even medical expertise of their health state are included usually. Also, archaeology is used in the case of Lithuania, that bodies are found of people that maybe 50 or 40 years ago exhumated and then made some kind of DNA, other investigations of these archaeological evidences. So yeah, other disciplines do participate, at least in the national level of Lithuania.
Okay, thanks a lot, Yvonne. Yes, please.
Sorry, is that me? Yeah. No, I would just add that the same is also true in international criminal prosecutions. It's not uncommon for historians to testify, to provide evidence as to their own archival research. I suppose there was also, I think, in part the question something about publishing research, and I sit on the editorial committee of the Journal of International Criminal Justice, and we are just about to publish a piece that talks about whether atrocities committed in the Francoist regime in Spain could constitute genocide. And of course, when you have lawyers reviewing this, they say, well, of course, this predates the Genocide Convention, and so, you know, there are issues. We're into the principle of legality and these issues, but the principle is that the historical reflection on and the historical research on, you know, whether those crimes fit within contemporary understandings of international crimes, I think is really valuable, and that's why we've made the decision to publish this piece. So yeah, I would encourage the person who asked the question to please do publish your historical research. Think about avenues, you know, like international law journals or international law fora, even if it's just blog posts or something like that, just to bring your research to the international criminal law community as well.
Thank you very much, Yvonne. So maybe there are some other questions that we can address. I think we can have some 10 more minutes for discussion, because I think there were a lot of really interesting points touched upon. So anyone? Okay. I think we had a really good run. It took quite a lot of time without tea breaks, so really sorry for keeping you locked to the screen so long. But I think we exchange very important views, very important knowledge, and all these, I should say, little events, they still put themselves in a much more broader picture. And the broader picture is that, as I said, we need to think about justice, even though up to the moment we cannot guarantee that justice, whether the, let's say, the perpetrators are flying through the countries or they are staying in the countries. But unfortunately, we, first of all, perhaps need to have very strong dogmatic, jurisprudential, and legal background, and to perhaps to see a little bit in the future what will be needed. And this is the job that you all are doing, and this is really great. We can again, we can learn from the past experience, we can look into future, and of course we shouldn't forget that we are talking about real people, real victims, and really the need of the justice. And not only in Ukraine, there are many places in the world where the justice is not served. And I hope that someday situation will change. So if we don't have any more questions or comments, I would like to thank everyone very much for the participation. It was a pleasure and honor to be with you, to listen to you. And the video of your presentations will be available on our YouTube channel. So it's forever. as long as the stars will shine. So have a great forthcoming weekend, and I hope to see you in the other discussions. So that's all from me.
Thank you so much.
you.
See you.
Thank you, everybody.
Thanks, everyone. Bye.